I think he's realizing that maybe he's made a mistake. The tariffs are hurting the economy. The Congress, when they go back to their districts, are getting an earful from their constituents who say these tariffs are raising prices or are going to raise prices. So if you act first and ask questions later, and you use an axe when you should be using a scalpel, there are going to be mistakes. But that's not a constitutional crisis as long as when the court says that was a mistake, you can't do it. He obeys that.
Hello and welcome to the Trump Report with me, Louis Sykes. Today we're joined by Suzanna Sherry, Professor Emerita in Law at Vanderbilt University Law School and expert in US constitutional law. Suzanna, welcome.
Thank you.
A US judge has said that he has probable cause to find the Trump administration in contempt of this order to stop deportations to El Salvador. Can you explain for us what that means in practice and how big of a challenge it is to the Trump administration?
Well, what that means in practice is that he has given them until next week either to purge or cure the contempt, which means bring back the Venezuelans from El Salvador, or he will refer the matter for prosecution. So this is a criminal contempt, not a civil contempt, which means the judge can't just impose it. There has to be a prosecution, essentially a trial. The officials who are being subject to the trial for contempt might, in fact, even be entitled to a jury trial. So if the administration doesn't return the Venezuelans to the United States by sometime next week, the next step would be a prosecution. Now, of course, several things have to happen. The Judge Boasberg, has to hold hearings probably to figure out who to hold in contempt, because it's not clear exactly who made the decision or which people made the decision either to have the planes take off in violation of the order or not turn them around in violation of the order. So he has to figure out who to charge with contempt. And then there's the issue of who is going to prosecute. Normally that would be a government attorney, but the government attorneys work for Mr. Trump. And so probably no government attorney will be allowed to do that. But the judge has said that he has the power, and I believe he does have the power, to appoint someone to prosecute the contempt.
And what can you tell us about Abrego Garcia, who was deported from the US when it seems like he shouldn't have been?
This is the other case. There are two ongoing cases about immigration. One is about whether the Trump administration committed contempt of court by sending 3 plane loads of Venezuelans to El Salvador in violation of a court order saying that they could not do that. The other one is about a man who is not a citizen and was apparently here illegally, who was deported to El Salvador, but the administration originally said it was an administrative error, that he shouldn't have been deported. For one thing, there was an outstanding court order from 2019 that said that although he was deportable, he could not be deported to El Salvador because he would face persecution there. And so the administration started by saying this was an administrative error. They've now changed their tune. The administration now says, no, it's perfectly fine to have deported him. But originally it was an error. The challenge to that is how to get him back. And so originally, a district court judge, a trial court judge, Judge Zines, ordered the Trump administration to effectuate and facilitate his return. The Supreme Court basically upheld that order, but they said you can't make the government effectuate his return. You can only make them facilitate his return. So it's not quite an order to return him. It's an order for the administration to do what it can to return him. Now, what's been going on in that case is that the Trump administration has been stonewalling the judge. The judge has asked for updates. The judge has asked, what have you done to try and facilitate his return? And basically, they're not answering. So now the judge has given This is a civil case. This is not a criminal case. This is a civil case brought by Abrego Garcia's relatives. And in our civil system, the parties are entitled to what's called discovery. That is, they're entitled to ask questions of the other side. They're entitled to demand answers about things. And what the judge has done in this case is order expedited discovery. And so she said, you have 2 weeks, and you, the defendants, the Trump administration, you have to answer the questions that these plaintiffs, that Abrego Garcia's family is asking. And she's in particular ordered 4 officials from the State Department and the Department of Homeland Security to answer questions about what's going on, where is he, what has the government done to try and get him back, and so on.
And a lot of these deportations to El Salvador are being based on this Alien Enemies Act of 1798. Is it usual to base a pretty significant policy like this on a law that old?
The problem is not that the law is old. We have a lot of very old laws, including the laws that establish not as old as your laws, but including the laws that establish the whole federal court system. So the problem isn't that it's from 1798. The problem is that since 1798, it's only been used 3 times, and always during a declared war. So what the Alien Enemies Act says is that the president has the power to deport people if there is a declared war with a foreign government, or if a foreign government has, and now I quote, perpetrated, attempted, or threatened an invasion or predatory incursion. So the question here, at least one of the questions here, is that true? The Trump administration says that this Venezuelan gang has committed an invasion against the United States, and that they're connected to a foreign government, that is, to the Venezuelan government. I think that's probably not true. And at some point, a court, probably the Supreme Court, will have to decide whether he properly invoked the Alien Enemies Act. That's one question. The second question, which the court has already answered, is even if he properly invoked it, what has to happen before he can deport these people? And the Supreme Court has said that they have to get a hearing, which the ones who have already been deported did not get.
So he could be in quite hot water over the invoking of that law then?
Not so much in hot water for invoking it. I mean, government officials do things that turn out to be unconstitutional or illegal all the time, as long as they're doing them in good faith. And we have to give him the benefit of the doubt on that. The fact that the Supreme Court might ultimately say, no, you couldn't do that, doesn't put him in hot water. It just means that he can't do it anymore.
Coming back to that issue of contempt of court, I mean, what is going to happen next on that? Because the Trump team seemed pretty keen to carry on here.
Well, the administration has already appealed the finding of probable cause for contempt up to the next level, which is the Court of Appeals for the District of Columbia Circuit. It's an intermediate appellate court, and presumably, if he does not get relief there, he'll go to the Supreme Court. At the very least, he will probably ask for some kind of stay. That is, don't hold the contempt hearings yet. The judge has already, as I think I just said, the judge has already given him until next week to either cure the contempt, or the judge will start trying to figure out who to hold in contempt. And then there'll be, I mean, assuming this continues to go forward, then there'll be a trial. Maybe somebody will be found in contempt, probably not Trump. My guess is that the court is not going to try to hold Trump in contempt. So it will probably be the head of ICE or somebody in the State Department or whatever. Then that contempt finding can be appealed to the Intermediate Court of Appeals, and then ultimately to the Supreme Court.
And is Trump safe in this seeming assumption that the Supreme Court will ultimately continue to back him?
Well, they haven't fully backed him. They've backed him on some things. For example, the last year's immunity decision was very broad and very favorable to any president, including Trump. But the two most recent cases, one involving the one involving the mass deportation of Venezuelans to El Salvador, and the other one involving the attempt to get back the mistakenly deported man, Abrego Garcia. Both of those, he basically lost in the Supreme Court 9-1. So what the Supreme Court said in the case of the mass deportations is, first of all, they are entitled to hearings, and they had not gotten hearings, and that was a 9-0 decision that they're entitled to hearings before they're deported. But what the court said is they challenged him. The deportees or the detainees brought their suit under the wrong statute and therefore in the wrong federal court. They have to challenge it in Texas where they're being held, not in DC. And they've already done that. So those suits are now pending. But that wasn't a win. That was a procedural wrinkle that says you got to go do this somewhere else. Basically the same thing with the order to effectuate and facilitate the return of Abrego Garcia. The Supreme Court did say, well, you can't say effectuate, that's too strong. But basically, the court upheld the district court's order. Now, Trump is saying that he won both those cases, but he didn't.
And does that, you mentioned the immunity decision on Trump from last year. I mean, that decision doesn't exempt anyone else but the president. So other members of the administration could be found in contempt of court, and they could face prosecution still, couldn't they?
Well, they could face prosecution and then be found in contempt of court. It works that way. They have to be prosecuted for contempt of court before they're found guilty of it. But yes, they could be found guilty of contempt of court, and then the judge could impose either a fine or jail time. Those are the two remedies for criminal contempt of court. But there is one catch, which is that the president has the pardon power. And it's not 100% clear that he can pardon a criminal finding of criminal contempt, but he probably can. And so he could just wipe out the contempt.
And I mean, the presidential pardon, that goes as far as Trump would like it to then. I mean, he could get around all of this using presidential pardons?
Well, he definitely can pardon someone who has been criminally convicted who has been convicted of a crime, of a federal crime. The question is, and that's unlimited. He pardoned all of the January 6th rioters. He can pardon anybody he wants. There is this small question of whether it reaches as far as pardoning a finding of criminal contempt. It probably does. And if it does, then he can pardon anyone he wants. And there is some discussion, and this has not been settled, about whether even if, for example, he would be held in criminal contempt, could he pardon himself? Nothing in the Constitution says he can't, but that would be a very odd reading of the Constitution.
But the Trump team are still playing by the rules here, though, aren't they? I mean, they have issued these challenges to the Supreme Court to court orders like those halting the ending of birthright citizenship. You know, they aren't yet just forging ahead and ignoring the courts, are they?
No, they're not. They're coming close. And the next couple of weeks, I think, are going to be the real test. That is, they are being ordered to do various things, produce people for testimony, give answers to questions, decide. Some of them may ultimately be referred for prosecution for contempt. They're being ordered to do things that they might decide not to do. But so far, what they do is they stonewall, they play games. There's been a lot of, they send a lawyer to argue before a judge, and then the lawyer doesn't know anything. The judge, particularly in the case of Abrego Garcia, the judge would ask the lawyer things like, well, where is he now? I'm sorry, I don't know. How did this mistake happen? Well, I asked my client that. but I didn't get satisfactory answers. By the way, the lawyer who did some of that, who said I didn't get satisfactory answers, and who told the judge that it was an administrative mistake to deport Abrego Garcia, he's been fired. So the Trump administration is pushing to the very edge of the law and maybe a step or two over it, but not yet outright defiance.
And have we been this close before then of pushing it up to that line?
No, we've never been this close. There are sort of three historical comparisons, parallels. The first one was Andrew Jackson, who the Supreme Court said he could not order the removal of the Cherokee tribe from their native lands to the west. It is apocryphal that he supposedly said, John Marshall, the Chief Justice, has made his decision. Now let him enforce it. But it's the kind of thing he might have said. But history is a little bit unclear about exactly what happened. Also, that was almost 200 years ago. And the Supreme Court hadn't really gotten its footing yet. It was not clear that everybody had to obey the Supreme Court, including the president. It is now clear that that is the case. So that was the first example. The second sort of parallel is Abraham Lincoln, who thought that the Dred Scott decision was completely wrong, unconstitutional, immoral. But he said all that, but he also said, and I am going to seek every legal method of getting it changed. He was not going to defy it. And then there's Richard Nixon in the early 1970s, when he was ordered to turn over the tapes from the Oval Office that were going to show that he at least knew about and covered up and possibly planned the break-in at the Watergate, the break into the Democratic headquarters in the Watergate office building. When he had to turn those over, there was some talk that maybe he would disobey the Supreme Court. He didn't. He turned them over and resigned because that he wasn't going to defy the Supreme Court. So there are parallels, but they're parallels that go mostly the other way. No president has ever just said, I don't have to listen to you.
And what is the procedure then for challenging a lot of these orders that have blocked Trump's plans and executive orders? And is Trump following those by the book, or as you'd expect him to?
In general, the answer is yes. That is, so somebody files a challenge in a federal trial court, the lowest level of trial court, and the Trump administration responds, and they file briefs, and they make arguments, and so on. And then, if he loses, he goes to the next higher court, the courts of appeals, the intermediate courts, and asks either to overturn what the district court did, or most likely to issue a stay, because most of these things are still in very early stages, and most courts have not said, I've heard enough, this is wrong, this is unconstitutional, you can't do it. Most of them have issued what are called temporary restraining orders, or TROs, or preliminary injunctions that say, you can't do this while this case is proceeding. We'll take our time and listen to all the arguments, and then we'll make a decision, but first you got to stop. And so he's appealing all of that. He appeals it to the Intermediate Court of Appeals, and if he loses there, he's been appealing it to the Supreme Court. And sometimes the Supreme Court has acted very quickly, and sometimes the Supreme Court has said, this is not an emergency. We'll set briefing and oral argument schedules for a couple weeks from now, a month from now, and we'll take our time about it.
And how much of one more time. And how many of these legal challenges over Trump's plans in office, essentially, are going to have to go through the Supreme Court? And on top of that, how much of an undertaking will that be?
Well, I think at the moment there are something like 150 cases pending challenging his various acts, and most of them are going to have to go through the Supreme Court because most of them raise novel constitutional issues. And that is a major undertaking. Now, some of them might not get there until before the end of the term, the Supreme Court term, which ends at the end of June or the beginning of July. Some of them might be able to wait until it begins again in October, but some of them are going to have to be decided very quickly. And it's a major undertaking. This is 150 new cases. The Supreme Court hears oral arguments until the end of April or the beginning of May, and then for the next 2 months, they just write their opinions on all of the argued cases from the term. So far, only about half or fewer than half of the cases that have been to the Supreme Court this term, only fewer than half have actually been decided yet. So they have the whole second half of the term that they have to write opinions for. And the cases that come out later are generally the ones where they're divided. So that means you have to have a majority opinion, and you have to circulate the majority opinion to both the majority and the dissenters. And the members of the majority can ask for changes, and then you circulate another one. And then the dissenters write their opinion, and they circulate that. And then the majority writes a new opinion that responds to the dissenters. So they're very busy in May and June, and they're going to get even busier.
And the fact that so much of this is having to go through the courts, and that Trump is seemingly trying to keep challenging and dance with the court, I think was the way you were saying it before. How much of that is a departure from the way that, at least in recent history, US presidents have treated the Supreme Court?
Oh, it's completely unprecedented. Most presidents have not asked for the kind of emergency relief at the rate that Trump is asking for emergency relief. Of course, most presidents haven't engaged in as much lawless action as Trump has. So this is completely unprecedented, but it is very much, I think, part of his strategy that he calls shock and awe. Just keep throwing stuff at the courts, throwing stuff at the nation, not caring whether it's lawful or lawless. Just keep doing it, and then we'll see what happens. I mean, when I talk about my students and I tell them how to answer their essay questions on the exam, I tell them, be specific. Don't just throw mud at the wall and hope it sticks. And I think Trump is throwing mud at the wall and hoping it sticks.
And in that case, then, I think it's been discussed already widely in the media that we are not yet in a constitutional crisis. But are we then on the path to that constitutional crisis if the Trump administration continues that kind of act first, ask legal questions later?
As long as they obey the court's answers to the legal questions, we're not in a constitutional crisis. We're in a difficult period, and people will suffer because of it. The acting first and asking questions later means he's going to make mistakes. And some of them are going to be legal mistakes. Some of them are going to be policy mistakes. For example, he keeps going back and forth on tariffs. Now, he probably at the moment has the authority to issue these tariffs. They've been challenged. I don't know where those are in the courts, but he certainly has more authority over tariffs than he does over these kinds of emergency deportations. But he's going back and forth because I think he's realizing that maybe he's made a mistake. The tariffs are hurting the economy. The Congress, when they go back to their districts, are getting an earful from their constituents who say these tariffs are raising prices or are going to raise prices. So if you act first and ask questions later, and you use an axe when you should be using a scalpel, there are going to be mistakes, but that's not a constitutional crisis as long as when the court says that was a mistake, you can't do it, he obeys that.
Given that, how concerned should we be about the strength of the US's constitutional structures?
Well, that's sort of an interesting question. I mean, the Constitution has worked very well so far, but any institutional arrangement, including the US Constitution, including the three branches of the US government, can't be any better than the people who serve in it. So there's no magic bullet. There's no constitutional or institutional arrangement that can prevent disaster if the people who serve in those institutions are corrupt or incompetent or cowardly. So Jack Goldsmith, who is a Harvard law professor who worked in the George W. Bush White House, and he's a conservative, and he said recently, much of our law depends on a presumption of regularity in the presidency. It depends on the courts thinking that they can trust the president to comply with orders and to be honest and truthful in court. That's true. But then that means if you can't rely on that anymore, there's a big problem. 60 years ago, in the 1960s, when Earl Warren was the Chief Justice, the court ordered the Army to do something. That wasn't unusual. The court ordered lots of people to do lots of things. But one of his clerks, one of his young clerks, was a little worried and asked Warren, Chief Justice Warren, how are we going to make the Army do this? And Warren said, don't worry about it. They're going to do it. And the clerk kept pushing and asking, yeah, but what if they don't? And how do we make them? And finally, Warren, who was by this time a little bit annoyed, said, look, if they don't follow our orders, there's going to be a constitutional crisis and nobody wants that. So they're going to do it. I'm afraid we might have reached the point where they're not going to do it. And that's a real problem.
Well, Suzanna Sherry, thank you very much for joining me today on the Trump Report.
It was my pleasure.